Our next panel is Crypto Unleashed, and we have a terrific group assembled here. Let me start with our moderator, Kristina Littman, a partner at Willkie in DC and co-head of the firm's digital works practice. Kristy previously served at the SEC for over 11 years, where she was the chief of the crypto assets and cyber unit in the SEC's Division of Enforcement. Kristy, welcome. We also have Jennifer Leete. Jennifer's a partner at Cravath. She previously served at the SEC for over 20 years, where she was Associate Director in the Division of Enforcement. Jennifer, great to see you. Welcome. Very pleased to welcome Matt Solomon. He is a partner at Cleary, based in DC. Matt previously served in the government for 15 years as a white-collar prosecutor and a unit chief with the DOJ, and also as a senior official with the SEC as Chief Litigation Counsel. And I think I completely just skipped one. Sorry, Bridget.
Like the best
Bridget is a partner at Baker Botts, based in DC, and chair of the firm's litigation department. Prior to joining Baker Botts, Bridget served as counsel in the SEC's Division of Enforcement. Bridget, great to see you. Welcome.
Thank you.
And finally, James Walker is with us today. He's a partner at Perkins, Coie, based in New York. He has over 20 years of experience representing clients in government enforcement actions with a focus on fintech clients facing securities regulatory matters. Kristy, let me turn it over to you.
Thanks, Bruce. Welcome, everyone. It's great to be here. It is a new day for crypto. Obviously, this is an enforcement forum, and we're here talking about crypto, and it might feel like an oxymoron, but we are, there's definitely still activity in this space on the enforcement front. We're going to talk a little bit today about kind of what we think might continue from the last administration, what we think new areas of enforcement might look like in the crypto space. We're also going to talk about Project Crypto, which, while it is a policy initiative, impacts, I think, our practices and certainly our clients, and we spend a lot of time talking about it with clients. And then we're going to try to take maybe a longer view look at what we think the future of crypto enforcement looks like kind of as crypto becomes more mainstream and more integrated into some of our TradFi clients and their world. So I'm going to start, obviously you've all read about the kind of change in the winds at the SEC, particularly when it comes to crypto enforcement. Even before Chairman Adkins was confirmed, we saw under Acting Chair Ueda a number of dismissals of ongoing litigation against crypto token issuers or intermediaries who were acting as exchanges. And we saw a lot of high-profile cases that maybe had been talked about publicly by crypto companies. I think there was a period of time where everyone tweeted about their investigation because it felt like if you're not being investigated by the SEC, do you even matter? So there was always a lot of public discussion about really confidential investigations, but we saw a lot of those closed. So we see a lot of closures of investigations, dismissal of litigation. I think first, the first thing we're going to talk about is what from that kind of era of actions do we think is going to continue in the next administration? I'm going to start with Matt, who can maybe give us a little bit of an overview of what's happened this year in crypto enforcement.
Sure. So it's been an eventful year since the last time we were here, and unless you've been living under a rock, you know that many of the cases that were percolating through the investigative process at the SEC and a lot of them that were in court are no longer investigations and no longer litigations. And I guess most prominently, we saw, obviously, during the Gensler administration at the SEC, attacks on the platforms. You had Binance, Kraken, Coinbase. You had Cumberland that had just been sued by the SEC. Prior to the election, a number of issuers had been sued. OpenSea under investigation. Some DeFi protocols were under investigation or in lawsuits. And various other aggressive ways to begin to dismantle the industry. All of it has essentially gone away. I have one case left that the SEC has been silent on for 6 months, which looks only like a Section 5 case, so it's a head scratcher why that case is still percolating. I don't know if anybody else has cases like that, but if you do, there are probably very, very few of them, and I suspect ultimately those cases will be closed unless there's some kind of fraud hook to them. And this was really consequential. I remember clients asking me before and after Trump got elected, so what do you think are going to happen to litigations? And I used to be the chief litigation counsel at the SEC, and I'd never seen a situation where the agency had gone in and outright dismissed a number of cases at once. I don't think it's ever happened. If it has, please tell me after this panel. I didn't anticipate that there'd be dismissals across the board. I thought the cases ought to be dismissed, but I thought they would end up perhaps as settled matters or something like that. But I think appropriately, the Aegean stables were just washed clean. And that's taken some time. Another phenomenon that's happened is some crypto firms who had settled cases and other companies that had settled cases, I think most prominently some of the financial institutions in off-channel, had gone back to the SEC and tried to undo their settlements. And the SEC did draw the line there. I suspect institutionally it was just too heavy a lift to undo settled cases. So some of those cases that we still think shouldn't have been brought and folks shouldn't have had to pay money out on, those did remain intact. But for crypto, everything was pretty much washed away. So where does that leave us right now? I mean, that's the point of this panel, but I think the registration cases obviously at this point are dead and buried. Those are simply not going to be brought anymore by the SEC. I think fraud cases, true fraud cases, are still under investigation and might be brought in the crypto space, depending on the facts of those cases and resources. I think the criminal authorities are going to continue to bring cases, BSA, AML type cases. Those will still be investigated. Those still will be brought. And there's, the Storm case, for example, got tried in the Southern District. That's still going on. You've got some money laundering prosecutions going on out there. But I think we're sort of in a wait and see mode. What out of the current crypto environment turns into investigations and ultimately litigations? I don't think the people inside the building know that answer, so I'm not going to try to speculate on that beyond saying we are in fraud land right now. Until we get a set of rules where you've got public companies that could actually break those rules, it's going to be, I think, very difficult for the SEC to condition practices of crypto firms. There's a lot of latitude right now. But I think we'll have a much better idea a year from now, and we can speculate about that. There'll be some other interesting things to talk about, but that's where we are right now. We're in a waiting game. I think Steph said it well. The agency is just getting its feet right now. They got a new enforcement director. Atkins only came on a few months ago. Staff departures have sort of taken a bite out of the agency. I think we'll know a lot more in the next few months.
Bridget, I understand you do still have some work in this space where we haven't seen outright dismissals or closures of investigations. Can you talk about what you're seeing?
Yeah, so we have a case now, and it is, they're investigating whether there was fraud, but by definition, they have to investigate whether it's a security first. So we're defending on both sides. It's a very aggressive staff. It's very isolating for the client because they're seeing all of these statements come out, almost daily, prior to the shutdown at least, about how crypto friendly they want to be and the staff wants to be approachable, and it's been tough in that regard, particularly if you're dealing with a client that really hasn't been opposite regulators before. So it's been tough in that regard, and it's interesting because I think that the cases we'll see that come out of crypto and are fraud based, I feel like they're going to have to be really big cases, right? So as to not discourage what Atkins and is saying about being crypto friendly, a footfall or a negligence-based fraud, I don't think we'll see that. I think it's going to have to be kind of a doozy, and whatever that looks like in terms of, the dollar value lost, or the fact that there was never anything underlying whatever type of token it was. And so what we're seeing is a very aggressive staff trying to really kind of peel away and kind of disprove facts very aggressively. So it's a disconnect for us, and we're managing with the client, but it's very frustrating.
And I'll add, the instances where the staff is investigating a token for fraud, I think are fewer and fewer right now. But I'm still seeing instances where a crypto company who may have a token also did fundraising through private equity rounds, and often those private equity investments have a component, a token warrant or some component where the equity holder is also going to have an opportunity to have token exposure in the future. I think I've seen instances where the staff is still investigating those, and in fact, one investigation pre-administration change, it's a fraud action, Our client had received a voluntary request for information. Recently, another party in that investigation, we learned, has received a subpoena. And so the staff has actually gotten formal order authority during this administration, it seems, for that case. But I think the premise of that investigation is that there was fraud upon the private equity purchasers of equity in the company, and not necessarily a token theory. So I think that, and that's not a change, right? That's what we saw in the FTX case. SEC didn't have to bite off the token issue there. They could say that FTX defrauded their equity investors. And so we're still seeing a continuation of that approach that I think, is probably not going to go away. But in addition to the enforcement, investigations that we're seeing continuing, I think even a lot of our clients are looking at the fallout from these dismissals and this shift and asking a lot of questions. And so there's still a lot of work to be done. Maybe Jennifer and James, I'd like to hear from you both, but Jennifer, we'll start with you.
Sure. I mean, we had a few matters closed. They were really essentially Section 5 cases, not fraud cases. And while I would like to think it was brilliant legal work on our part that led to the closures of the investigations, it was obviously partially a result of the change of policy. I mean, Commissioner Peirce, Chairman Atkins, they've been extremely clear that fraud cases where crypto assets are securities will continue. That work goes on. Our clients have really pivoted to trying to figure out what they can do, and to look for clarity, navigate the statements and the policy changes as they come out. My role as an enforcement lawyer is often to join calls, help them navigate that a little bit, and then remind them that the statute of limitations is 5 years. I think there's a real eagerness in the marketplace to get going with some token issuances and that kind of thing. And so it can be hard just to remind people the world has changed, maybe forever, maybe not.
I can echo much of what Jennifer was just saying. We have lots of calls from clients who believe that the age of regulation by enforcement is over, the U.S. is open for business, and here are our 50 new product offering ideas that we're going to do in the U.S. And, a lot of times part of the conversation is, yes, the SEC is not likely to be looking to bring enforcement actions, but the law hasn't changed. And we still have to think about, what are the standards that were in place, what's happening in developing case law, and the other regulatory regimes that are touched by some of these potential product offerings. It's always a bit of a cautionary conversation, to say the least. The other thing is that there are a number of clients who either decided to take their product offshore initially, or were here and went offshore. We're now looking to come back to the U.S., saying, the U.S. is open, let's go. And they are trying to time how to do that, given what appears to be happening in terms of regulation and enforcement in the U.S. And so helping to navigate that has been an interesting challenge.
Thanks, James. So turning to what we think might be new in the crypto enforcement space, I think one thing I want to talk about is digital asset treasury companies. And for those of you who are not familiar with that term, the concept is essentially that you have a public company, and hopefully you're all familiar with MicroStrategy, but it's a public company whose primary, operating function is to invest or gain exposure to crypto. And MicroStrategy has been very successful in that endeavor, and so I think there are a lot of folks that want to get in on the action. And in particular, we're seeing public companies, and this is really kind of not different from what we've seen with different popular kind of trends, many going decades back, but existing public companies whose prior operations were minimal, but they're kind of using that shell to renew their interest and turn their focus to investing in crypto. And so I think there are questions around, the certainly disclosure issues, insider trading issues. So I'm hoping Matt can talk a little bit about kind of what the the pitfalls are to look out for around digital asset treasury companies.
Yeah, I mean, I can scratch the surface on that. Maybe you can pick it up because I know you've counseled clients on these issues, but I've read, like everybody else, that 200 public companies have been sent requests for information by FINRA and the SEC, digital asset treasury companies. I didn't know there were 200 public companies doing this. None of them called me. I think that suggests to me that, and I think somebody said this earlier on an earlier panel, just because you're in the business of crypto or want to be in the business of crypto, it doesn't inoculate you, obviously, from SEC scrutiny when it comes to potential disclosure issues, insider trading issues. These are exactly, again, the issues that Steph flagged on an earlier panel that I think are still ripe. And we saw with Coinbase, for example, it's been publicly reported that Coinbase was under investigation in relation to its number of subscribers. Maybe that case has gone away, maybe not. I don't know. But you could substitute Coinbase for Netflix, and you could see a similar investigation of a non-crypto company. So I think the SEC is looking to make sure that the current rules governing securities transactions apply to companies that are in the business of crypto. And I don't know if you've got anything to add specifically about how you're cautioning clients who are public companies.
So we've had a lot of approaches, and we've been involved in a number of matters where either you have a company that's decided to adopt a digital asset treasury strategy, or a company that's investing in a digital asset treasury strategy company. And a lot of the discussion is around navigating, are there risks in this non-Bitcoin crypto asset still being considered a security or offered as a security, or frankly the same questions that we've had in the past. And so there's a lot of discussion around that, a lot of discussion about the Investment Company Act and whether that could get triggered depending on how that question is answered, and how to navigate those issues. And it's one thing when it started with talking about ETH or talking about frankly even Solana, but then it stretched to NFTs, to meme coins, to basically any digital asset under the sun. And so it's an interesting time, given that people are thinking fairly broadly about how these digital asset treasury companies might work and how they might be interesting investments.
I mean, just to jump in, like Matt, I'm not involved in any of these cases at the moment, but if a public company is going to hold crypto, whether it's a little crypto or a lot, all of the usual rules for public companies apply, and it takes the question of whether the particular crypto asset is a security off the table. So, accounting issues, misstatements, risk disclosures, all those kinds of issues that we've been familiar with for decades in public company cases could bubble up in an investigation. So this may be an area, depending on the behavior in the marketplace, this could be an area where we see a fair amount of activity, I would think.
I think so. Reg FD is another, risk area there, right? Because I think a lot of these companies have asset managers who want to take large stakes, and if they're disclosing to those asset managers that they're going to announce a shift in their focus that likely will result in the price, price bump, that's going to be problematic. I'm also seeing a lot of asset management clients who are investing in the underlying asset, the token that the digital asset treasury might turn its focus to, and saying, if I'm going to, if I'm learning information from this company that they're going to shift their focus or make an announcement about an impending large acquisition of this token, do I need to restrict in the underlying token? And so there's still a lot of kind of historic types of questions and concerns that I think bubble up from this industry.
And I think just carrying on a point you made, Jennifer, in terms of that the idea of public companies holding crypto, it'll be interesting to see, depending on the amount, right, if it's a material amount, and what those risk disclosures look like, and to see if we see some enforcement area cases brought there, because I imagine that depending on the size, of course, that there would be some significant bulking up of what that needs to look like.
Yeah, and I guess while we're on the subject of what's coming up, we should probably talk about the states. This is something that, at least to me, has been a bit surprising. We've obviously seen Oregon and their investigation of Coinbase, where they're making essentially the same allegations that were made federally and trying to do that in relation to Oregon state law, and we'll see how successful that ends up being. We haven't really seen copycat or similar cases, at least I haven't, from other states yet. I thought we might see more. That may be because a number of states are taking actions in relation to the Trump administration. It may be that there's other things going on that states are prioritizing right now. Folks are probably familiar with the Calci-related cases for sporting event contracts, for example, and there's some activity there across multiple states. But I'm a bit surprised that states haven't picked up the mantle more cleanly at this point. But again, I think it remains to be seen. I think it's taken some time for states to coordinate. I think there's a number of people actually from the Department of Justice who are going into state AG's office, in particular Maryland, New Jersey, places like that. So I think, again, we probably want to stay tuned to see whether there's more activity in the months ahead. I expect that there will be, and that's probably just for the crypto cases. That's probably where the action is going to be, because I agree for the SEC, public companies, yes, but beyond that, there's just not going to be crypto-focused investigations or litigation anytime soon.
But it's tougher, right, for the states, because they're not going to have, because a lot of them were piggyback, right? They're not going to have that the case essentially built, and so I think it will be interesting to see. But I think at the state level, resources, expertise, that could be, an issue that they're going to have to tackle. Maybe they make new hires to the extent they don't have them, but I do think it'll be interesting.
Yeah.
They may be waiting to see what the SEC does also, out of concern for preemption and that kind of thing. I noticed there was a letter from a couple dozen red state attorney generals to the SEC in response to one of the recent statements on crypto, basically asking for sharp, narrow definitions, because they're concerned about preemption affecting all kinds of state laws in various ways. So it made me, I hadn't thought of it before, but it did make me wonder whether they're just holding back to see how things develop a little.
I think it's a fair point. I mean, and it's a good segue to our next topic, which is Project Crypto. But if you are a state regulator and you are interested in enforcing in this space, particularly if you just kind of want to make a point that's maybe anti-administration, you could see that being a very tempting area for states to focus on. But you also have the SEC Crypto Task Force pumping out, and the divisions pumping out guidance that is meant to give the industry comfort. And while it's non-binding, it's not a great look, I think, particularly in a litigated action, for a state to be saying that certain conduct is unlawful, and for the respondent or defendant to be able to say, but look, the SEC, who's kind of, should be considered the reigning subject matter expert here, says that this conduct is fine.
I think that's a really good point, because there is still law out there that was made, favorable law for the SEC. It's still good law from Southern District of New York and Northern District of California and elsewhere. But if there is the threat of preemption, you're right, all of that could be for naught. I wonder how realistic that is, only because obviously you need market structure legislation to have preemption. I imagine the states are going to fight kicking and screaming not to have preemptive effect for a market structure bill. But that would also explain why in private civil litigation, which I know we're not here to talk about, although it is kind of relevant in terms of potential risk for companies, I'm not seeing a ton of new crypto cases filed there either, including by folks I know at some of the mainline plaintiffs' firms. That also may be because they're in a wait-and-see mode. They're up against guidance from the SEC, not across the board, but meme coin staking, various other guidance that's made clear the agency's views. And that does present some headwinds. And I think we saw that most recently in the NFT case from Judge Olgan out in Central District of California, where he just dismissed a case. The Board Apes case, folks might be familiar with that. That case was dismissed. It's now been amended for the third time. But the judge there, even absent guidance from the SEC, took a pretty pro-defense view on NFTs. So it may be, you're right, the states, private plaintiffs, there's still activity there, but we have to wait till there's more closure on the federal level before they feel comfortable throwing a ton of resources into these kinds of cases.
So we're going to talk next about Project Crypto. Obviously, this is a policy initiative, although I think a lot of the statements that you've seen around the Crypto Task Force and Project Crypto do emphasize a desire to focus more on policy and rulemaking and less on enforcement. But these guidance and no action relief that we see coming out often evoke calls from clients to talk through how this impacts them, where are the guardrails and what can they do and what comfort can they take from these. So we're going to talk about a few specific pieces of relief that have been put out. We'll start with SEC custody no action relief that was recently issued out of the Division of Investment Management. And I think many of us had custody investigations during the last administration, and we're seeing some specific no action relief that folks can rely on. James, do you want to give us an overview of what that relief looks like?
So Simpson Thacher submitted a letter essentially seeking no action relief where a registered investment advisor or regulated fund turned to a state chartered trust company to essentially act as a bank and to custody crypto assets, and whether it would have the comfort that there would be no enforcement action based on having done that. And before this, there certainly was a question about whether or not state chartered trust companies satisfied the bank or qualified custodian definitions under the Investment Advisors Act and the Investment Company Act. And the SEC granted that relief. Essentially, Simpson argued that there's sufficient oversight under state regimes, that they make sure that there are rules and policies and procedures in place to make sure that customer assets are safeguarded, and the SEC took them up on that argument while also announcing certain things that need to happen annually, the type of oversight that needs to happen, and in doing so essentially answered the question that remained as to whether or not these state trust companies really satisfied the definition of bank, whether or not they had a substantial portion of their assets that were essentially being, or a substantial portion of their business was involved in receiving those deposits, and whether or not they were acting as fiduciaries under state law. So that relief was granted, and that certainly changes the landscape. However, it was interesting and important that Commissioner Peirce made a statement about what the no action relief does and what it doesn't do. That it's focused on the custody provisions of the Investment Advisors Act and the 1940 Act, which applies to funds and securities and similar investments respectively. It only addresses client crypto assets held by registered advisors and crypto asset investments of regulated funds that are subject to custody provisions. And so it does not answer this question for broker-dealers, for example. It also covers tokenized securities, which is an interesting topic. Those are equity and debt securities that have been formatted as crypto assets. There are also other questions about best interest. How do you determine whether or not it's in the best interest of the client to custody with a state chartered trust? Doesn't answer whether or not state trusts can also custody non-crypto assets, and there are also questions around bankruptcy. But in any event, it certainly moves the field forward in terms of these state trust companies.
I'll just mention, I agree. It definitely moves it forward and provides comfort for asset managers who are looking for places to custody tokens in a compliant manner. I do think it leaves a number of gaps. It doesn't provide relief for broker-dealers, right? This is exclusively related to investment advisors, qualified custodial requirements. I think there's also still a gap that perhaps can be fixed with some rulemaking. That is, the recent Reg Flex agenda did mention custody as an area that they want to make rules on or amend rules on. But I still see a lot of clients who have the concern that if you're an asset manager, you have a liquid token trading strategy, it's often easy to hold assets in a qualified custodian, a trust company, when you're just holding them. But if you have a liquid strategy, you need to go out and trade. And in order to engage in trading, you often have to leave that trust environment and move on exchange. And so that can be challenging for them to fulfill their fiduciary obligations with respect to their trading strategy while also maintaining the assets at a qualified custodian. And I don't think that that's been really resolved by this no action relief. So I want to talk a little bit next about some of the other guidance that, again, non-binding, but provides comfort for some of our clients. Jennifer, maybe you can start us off talking about meme coin and staking guidance that we've seen.
Well, there's been several different releases on these topics, staking and liquid staking. But it's important to remember that relates to protocol staking, so staking that takes place within the governance and operation of a network. It's too complicated to each of these things to really get too far into right now. I will just say, as with everything else in our space, as soon as the guidance came out, there are new questions, right? That as the staff ran through the Howey analysis in the protocol staking release, for example, it immediately raises the factual question: what is managerial activity versus entrepreneurial activity? Those kinds of questions are going to keep coming up, and eventually there's going to have to be some enforcement, even under these new, more permissive policy statements, because that's just in our legal system. That's how these questions get answered. I'm not necessarily predicting that anytime soon, but eventually we'll have to see some more clarity on some of these items. What they're trying to do is really hard, which is to write rules that give clarity and predictability to a brand new marketplace and a brand new part of the economy. They will continue to roll these out. If you look at Commissioner Peirce's statement, I think it was from February of this year, when the task force got going, there were 48 different questions or topics. That it's basically a to-do list for them. So they've issued a half a dozen statements on various topics. They have a long way to go. One thing I will say, what I hear from our clients is there's a very urgent demand or very urgent desire in the marketplace for more clarity on ICOs and tokens, and to James's earlier point, when can they come back on shore and issue tokens in the US, and what are the rules of the road there going to look like? And of course, if you go back over the last decade or so, ICO tokens, those tend to be the ones that look the most like securities. So that's the staff has a tough assignment there to draw some crisp line.
I do think the staking guidance, though, was particularly impactful, because I think that staking as a service, that activity, is an area where maybe unlike ICOs, a lot of asset managers and ETP and ETF providers viewed that activity as relatively safe, but they weren't sure if they could engage in it, right? And because I think the prior administration had charged cases where they alleged that staking as a service was an investment contract, and ETP and ETF providers, registrants, don't want to go out and engage in an activity that they think the SEC might think is unlawful. So in the wake of the statement on staking, we have seen ETF and ETP providers say, because they're leaving money on the table, right? If you're not staking, you're missing out on opportunities, and they have a fiduciary obligation to their holders. And so we have seen a lot of activity in that space, where now that the SEC has kind of informally blessed that conduct, it's opened up another avenue of profit for ETP providers.
What I thought was most interesting about the liquid staking and protocol staking statements by the SEC is that they took up so much conduct that was in question and that clients were asking questions about, and they essentially said, as a policy matter, we're going to decide that these are not significant managerial efforts. We're not worried about the fact that you custody these assets and then engage in the staking activity. We're not concerned about delegated staking. We're not concerned about ancillary services such as different reward schemes. We're not worried about aggregating crypto assets. We're not worried about early unbonding. All these things that were questions that we were wrestling with in talking to clients, they said, essentially as a policy matter, we're not worried about any of that. Now, there's no law that supports that. There's no market infrastructure law that is behind that. But at least that's the SEC's view now, and you take that as far as you can, which there's a question about how far can you take that.
Yeah, and there are a lot of caveats, as I recall. I haven't been through all of the guidance, but even on the meme coin guidance, I recall some footnotes and caveats. So I do think that the SEC is trying to give the guidance that it reasonably can. I think the industry is rightfully demanding that, but there's still a lot of work to be done in filling in the holes, and there's only so much comfort you can give clients, obviously, on the basis of non-binding guidance.
Exactly.
I think in addition to that, right, and to a point you were making, Jennifer, about these rules, kind of they have to create them from scratch essentially, is that it's always going to change. I mean, the nature of what this is always going to change. And so, how those rules are going to be able to be, are they going to be flexible enough to account for that? Are they going to be quicker with guidance, associated with how these things change? Because it's changing as we sit here, I'm confident. So while helpful, I think that's kind of part of the push and pull too. And, with the meme coins, to your point, Matt, I think the way that I looked at it is, it was, it's not a security unless it is, right? And then you kind of look at other guidance around tokenization and statements that Pierce has made around that. And the way that I look at it versus kind of a meme coin is that it is a security unless it's not, kind of, and I reserve the right to deny I said that to the extent I'm defending that in the future. But it's interesting, right? I mean, because I think it is trying to take, again, this evolving thing and putting some rules of the road around it, which we desperately need, but it's a huge challenge.
Jennifer mentioned earlier the desire to have guidance on token issuances, which, we haven't seen much. We haven't seen it yet, but we also haven't heard a lot of discussion of it. And I feel a little bit like there is a distinction emerging between token issuances and secondary market trading. There was a joint statement issued by SEC and CFTC around spot crypto trading and that activity. James, can you talk a little bit about that statement?
Absolutely. So on September 2nd, my birthday, although that has nothing to do with it, the SEC's Division of Trading and Markets and the CFTC's Division of Market Oversight and Division of Cleary and Risk issued a joint statement saying that essentially their CFTC and SEC registered entities, so CFTC registered designated contract markets, foreign boards of trade, and SEC registered national securities exchanges aren't prohibited under current law from facilitating trading of certain spot crypto assets. So they too can trade crypto assets. The applicable rules permit clearinghouses to partner with a custodian to maintain customer accounts, sharing reference pricing venues between national securities exchanges, designated contract markets, and foreign boards of trade, enhances effective market surveillance. And SEC Chair Paul Atkins came out with a statement saying that this is a significant move forward and bring innovation in the crypto asset markets back to America. Now, what's left out is how exactly will this work? In other words, will there be any regulation of spot trading of crypto assets by these registered entities? Will there be disclosure requirements? Are there restrictions? And frankly, how does this gel with the trading of traditional commodities and securities? Those are questions that remain to be addressed.
So, to wrap up, I think we're going to talk a little bit about what we think the future of crypto enforcement looks like. And, we're definitely at a turning point, I think, where crypto is becoming mainstream. And so you're seeing a lot of traditional financial institutions change their tune a little bit and start to embrace crypto and want to become more active in this space. We're seeing tons of talk about rulemaking. We haven't seen a lot of rulemaking yet, and there are a number of legislative efforts underway. Genius Act relating to stablecoins is already passed, but Clarity Act is floating around, which would provide for market structure regulation around the trading of crypto, and maybe draw a more clear line between SEC and CFTC jurisdiction. But I wonder, there's still going to be a number of SEC registrants who have to comply with SEC rulemaking. Even if CFTC ends up with a majority of the jurisdiction for spot crypto trading, you're still going to have SEC registrants who are active in this space. And so I think we'll talk a little bit about kind of what we think long-term that's going to look like in terms of SEC enforcement. And I'll give you a break. I'll start with Matt on this one. What do you think kind of some of the trends are going to be, and what do you think some of the lasting effects from some of the litigation will be?
Can you, sorry, I'm having trouble hearing you. I don't know if other people are too. What's the question? Sorry.
Future of crypto enforcement as it becomes more adopted mainstream.
Yep.
And what we think it's going to look like, but also how it's impacted by the existing litigation and judicial opinions.
I think we've touched on digital asset companies, for example. I think public companies are going to get scrutiny, and I think they will expressly get scrutiny because of the things that Chair Atkins and Chairman Atkins and then Commissioner Peirce have said. They've been very direct about the fact that they do expect that there are going to be cases in relation to crypto, and that there's no get out of jail free card just because it is now a more crypto friendly environment. So I think there'll be public company scrutiny. It's really hard to read the tea leaves about what the next few years are going to be. I'll say generally, and maybe other people have more specific predictions. I don't think we're going back to where we were before, ever. My view is that even if Kamala Harris had been elected president, the tide was already turning in crypto's favor. I think judges were already skeptical about the SEC's theories in a number of cases. There are permutations of theories. I mean, that was apparent from Judge Jackson in the District of Columbia, for example, among other judges. So I don't expect, absent like massive market dislocation where somehow the crypto industry got the blame, which I do not expect to happen, but absent something like that, I think we're still going to have a favorable environment over the next few years. And I think, again, so much is going to depend on the level of risk taking. I have clients who are taking very significant risks right now. They should be. They're business people. This is their time. They have a favorable environment, and the regulators have obviously given the green light to a lot of these practices. So much will depend, obviously, on elections. So much will depend on what the economy looks like. But I think we're in a very good period for crypto. We can't rest on our laurels. We still have to obey the rules and anticipate that there's going to be market structure legislation. You have a statute of limitations that's 5 years or more for fraud, obviously. But I feel pretty good about where things are, and I, again, don't think we're going back to the days of 2 or 3 years ago where there's going to be a sort of a wholesale effort to shut the industry down. I think we're already matured well beyond that point.
One thing I would just note, sorry, go ahead.
I was just going to say quickly that I agree with Matt that the judges were already moving in a direction. Judge Torres's opinion in the Ripple case, Judge Jackson's opinion in Binance, you already see a move in a direction that's frankly is somewhat supported by what Judge Jolgin did too in the Yuga Labs case. But the problem is that to the extent the SEC has made statements that go much further than we've ever been before, none of that necessarily sticks unless you do have a market infrastructure bill or you do have legislation and rules that will follow through. And right now we have a Clarity Act from the House that provides a certain infrastructure but contemplates a lot of rulemaking. A Responsible Financial Innovation Act that's going around the Senate with various changes. Both of them struggle with dealing with investment contract securities. We all struggle with investment contracts. They struggle with the decentralization concept, and doing any of that it's already in those bills that will require, frankly, years to get the rules that actually can implement any of it. And so what happens in the next administration, if it changes or whatever, is really just a question at this point.
And Jennifer, did you have something to add?
Go ahead. Well, just briefly, put me down as skeptical about Congress's ability to legislate anything. I was also going to say one thing we're very much seeing now at the SEC is almost an open door policy and a real ability for clients to talk to the staff, talk to commissioners, and that if the pendulum swings in late 2028, 2029, that will, even if rules change and attitudes change, that will take enforcement actions off the table in a lot of gray area kind of situations.
Yeah, one other thing, and we were talking about it as a panel, and something that I've been kind of looking at and focusing on is, when these cases start coming, and particularly in the SEC context, but also the private plaintiffs bar, what is material? What is a reasonable investor in this space? I don't think it is your traditional investor, right, in a blue chip company, and kind of shifting that. I think there are really interesting arguments that can be made there. and different things that these investors are looking at. And I think it's for many of us, right, when we kind of laugh and say, in your traditional investigation, if you're arguing about materiality, in most cases, it's kind of a bummer, right, because that's a tough hill to climb. But here, I think that there's not a lot on it. It's unlike, we saw obviously in Ripple in terms of the court talking about the expectation of profit and kind of looking at that. But in terms of what a reasonable investor is in this space, I think it's going to be really interesting to see how that develops.
Well, I look forward to coming back next year and seeing how much of this we got right. Thank you, everyone.